In the world of international trade and commerce, international commercial arbitration has become a popular and widely accepted means to resolving disputes. Rapid globalization has resulted in substantial growth in the volume of international contracts containing clauses providing for arbitration. With this, the availability and efficacy of international arbitration has become a positive alternative to the traditional course of international litigation. This presentation will address the advantages of international commercial arbitration in comparison to international commercial litigation. Before delving into the specific advantages afforded by the arbitration process, first it is important to quickly explore the concept of arbitration. So, what is arbitration? Arbitration is a process in which the parties to a dispute present their arguments and evidence to a dispute resolution practitioner, in this case, the arbitrator, who in turn issues a determination. The process is private and subject to the parties' agreement, can be confidential. Arbitration offers a flexible and efficient means of resolving disputes and focuses on the concept of party autonomy. The decision of the arbitral tribunal is final and binding, and the award handed down is enforceable. There is a commonly accepted notion amongst both the public and legal practitioners that the avoidance of litigation is an advantageous course of action. Unlike arbitration, courtroom litigation is extremely expensive and time-consuming, and although many cases settle before trial, settlement does not usually take place until the 11th hour, when money and time have already been readily utilised. Litigation does not afford the parties any privacy either, due to both media exposure and publishment of decisions. This can of course result in damage to the reputation of the parties. Further, litigation is also seen as unpredictable, so far in as you cannot predict the decision of a judge or a jury. In the case of many international commercial disputes, many technical and complicated facts and testimony are involved, which lends itself to expert arbitrators. This, of course, has resulted in the increasing popularity of alternative dispute resolution processes, one of which is international commercial arbitration. So, what are the advantages? Unlike litigation, arbitration affords party autonomy, which in turn allows parties the opportunity to choose their arbitrators. Because commercial trade disputes are complex and can vary in specifics, expert arbitrators who specialize in the particular trade or nature of the business can be chosen. Further, arbitrators commonly adopt a more international and pro-business outlook as compared to a judicial setting. Arbitration is famously known for a more cost and time-efficient process than litigation. This is because parties are able to decide the approach they would like the arbitral tribunal to take and directly tailor this to the costs and speed. Some seats of arbitration provide for rules offering expedited procedures, which can be likened to a summary judgment in litigation. Arbitration is private and confidential, and proceedings are not recorded in public records. Unlike litigation, where court proceedings are usually open to the public and judgments are reported, arbitral awards are not published and the proceedings remain private. This is an important aspect for companies in order to protect business relationships and reputation. International arbitration is seen as a way of ensuring a high degree of neutrality in the dispute resolution process. For example, arbitrators can, if the parties agree, be chosen so that they are of different nationalities from the parties. Similarly, parties are also afforded the opportunity to choose a seat of arbitration, commonly situated in another nation, so that the arbitration is conducted in a neutral location. A unique feature of international arbitration is that the decisions are final and binding on the parties, and they're non-appealable. This is distinctly different from court judgments, which can be subject to a long process of appeals. In summary, it is clear that in the appropriate circumstances, international commercial arbitration can afford parties a much more streamlined process than is offered in litigation. This can be advantageous in commercial trade disputes to allow businesses to continue to progress and to ensure that companies are not disadvantageously affected by drawn-out litigation.